Sometimes people ask me, friends and clients, you know, for estate planning, that's just a will, isn't it? That's all I need. And so the short answer is that yes and no, it depends on your circumstances. Estate planning, it's a legitimate phrase, looks at the transfer of wealth from one generation to another in a tax-effective and a risk-effective way. So in no particular order, when you're looking at all this sort of stuff, you have to look at, well, what if the person loses capacity? But, you know, they haven't died, so is there an enduring power of attorney document? Does it appoint trustworthy people? Is there a plan B in the document? And a whole stack of other things there. Is there an advanced health directive if there's certain wishes there, if there's a lack of capacity and treatment? Superannuation, as a matter of course, does not form part of an estate, so therefore does not form part of a will. So is there an appropriately drafted nomination to deal with super? Yes, you heard it. Super can't be dealt with by a will unless it goes from the super company to the estate. That doesn't happen automatically at all. Are there any existing trusts in place, like a discretionary trust or what some people call a family trust? The assets in those trusts won't form part of the estate, so they can't be dealt with under the will. So there'll have to be other things done outside of the will to pass control of those trusts along. There might be life insurance policies, and you'll have to form a view. Do they form part of the estate, or do we do nominations in favour of certain people? There could be a risk of huge estate litigation because of a whole stack of reasons. So there may be a need to look really closely at how assets are owned. So part of the estate plan might be to change ownership of assets, just so that when you die, there's not a big jolly fight and everything's ripped apart. So estate planning, it's more than just a will.